Okay, let's try and unpack this. Imagine the clock ticking down, like literally to the minute. A group of people are facing immediate removal from the country, the government citing national security. But these individuals, they're saying, hang on, we haven't even had a fair chance to speak up, to challenge this. This isn't just hypothetical, it's a really high-stakes situation that just landed on the Supreme Court's plate. And it raises some fundamental questions about due process and, the power of our courts. Today in the Deep Dive, we're getting into the details of a very recent Supreme Court opinion. It's AARP, ETALV, Donald J. Trump, President of the United States, ETAL. Came down May 16th, 2025. Now, it's a complex legal document, sure, but it really boils down to something incredibly important for all of us, which is the right to a fair process. Even when things are urgent, even when the stakes are, astronomically high.
Yeah, what's really fascinating here is just how fast everything happened. It really forced the courts to make these huge decisions under, frankly, extreme pressure. So we're going to look at not just the Supreme Court's decision itself, but also the really passionate arguments from the justices. Arguments about how much notice is actually due to people facing removal. And also the structure of our legal system itself, when it comes to things like class actions and emergency relief.
Right. So the core issue here, the president used the Alien Enemies Act. The goal was to remove Venezuelan nationals identified as members of Tren de Aragua, TDA, a designated foreign terrorist organization. The detainees, they immediately sought an injunction, court order, to stop what they called summary removal. So our mission today is to break down this legal battle, this race against time, the critical timeline, and what it all means for anyone curious about how justice actually gets served in these intense moments. Okay, so here's where it gets really interesting. This isn't just some abstract legal debate. It's a story that unfolded over mere hours. Really, it kicked off April 17th. A district court denied an initial request for a TRO, a temporary restraining order.
Right, a TRO is basically a quick, temporary court order. It's meant to stop immediate harm before it happens. And if we connect this to the bigger picture, the detainees said they got served removal notices just hours after that denial, and they were told, point blank, they'd be removed tonight or tomorrow. So naturally, that sparked a frantic legal scramble.
And frantic is the word. April 18th, things just went into overdrive. Look at this timeline. 12:34 a.m. Central Time. They file for an emergency TRO. Then, 12:48 p.m., they're pushing the court for a ruling by 1:30 p.m. Less than an hour. By 3:02 p.m., still no ruling. So they appealed to the Fifth Circuit Court of Appeals, their argument. The district court had constructively denied their request by not acting fast enough, and at the same time, they applied straight to the Supreme Court for a temporary injunction. I mean, the speed is just wow.
It really is, and it brings up a really important question. When does a court's silence or its delay become essentially a denial of justice? Especially in an emergency. And adding to the pressure, the government, they were in a separate hearing. They guaranteed no removals that day, April 18th, but they explicitly said they reserved the right to start removing detainees the very next day, April 19th, at 12:01 a.m. There was even evidence suggesting the government was already, taking steps, transporting detainees to an airport, things like that. The clock was definitely ticking.
So imagine that pressure. Removals potentially just hours away. Then, 12:52 a.m. Eastern Time on April 19th, that's just minutes before that midnight deadline Central Time, the Supreme Court steps in. They issue their own order.
That's right, a crucial intervention. The Supreme Court ordered the government, and I'm quoting here, not to remove any member of the putative class of detainees. This basically hit the pause button at the highest level. It preserved their ability, their jurisdiction, to actually consider the application properly.
Now, the Fifth Circuit, that's the appeals court just below the Supreme Court, they had initially dismissed the appeal. They basically said, look, the detainees only gave the district court 42 minutes to act. But the Supreme Court, in its per curiam opinion,
Which means by the court, like as a whole entity.
Exactly. They strongly disagreed with the Fifth Circuit's take on that timing.
Yeah, the Supreme Court said the Fifth Circuit got it wrong. They clarified that appellate courts do have jurisdiction to review orders that have the, quote, practical effect of refusing an injunction, unquote. And the key point they made was that the district court's inaction wasn't just for 42 minutes, it was for 14 hours and 28 minutes. And this was happening, remember, in the face of extreme urgency and a high risk of serious, perhaps irreparable consequences. So this wasn't just about correcting the timeline. It was the Supreme Court emphasizing that delay, especially when someone's freedom is on the line, can be just as harmful as an outright no. And appeals courts need to be able to step in.
Okay, so what does this all mean for the detainees? And maybe more broadly for how we understand due process rights, especially for non-citizens facing removal?
Well, fundamentally, this case reinforces a core idea. The Fifth Amendment's promise of procedural due process, it applies even to aliens in removal proceedings. This whole concept is meant to protect against mistaken or unjustified deprivation of life, liberty, or property. The court even looked back at its own history, like the Japanese immigrant case from way back in 1903. That case said, no person shall be removed without an opportunity at some time to be heard. It's a long-standing principle. And even more recently, Trump v. JGG, just this year, 2025, all 9 justices agreed that detainees under the Alien Enemies Act, they must get notice that lets them actually seek habeas relief before they're removed. It's not just about getting a notice, it's about getting notice that's actually useful, that gives you enough information and time to act.
And habeas relief, just to remind everyone, that's the legal action where you challenge your detention. You ask a court, is this lawful? So the Supreme Court looked at the notice given here roughly 24 hours before removal, and crucially, it was, quote, devoid of information about how to exercise due process rights. They found it just didn't pass muster. It wasn't good enough, especially when you consider the weighty interests involved. I mean, potential indefinite detention or being sent to countries where things could be very bad.
Precisely. So the court concluded, look, these detainees are entitled to more notice, period. They granted that temporary injunctive relief, stopping the removals to give everyone time. But, and this is important, they didn't decide exactly how much notice is required. Is it 2 days? A week? They didn't say. Instead, they remanded the case. That means they sent it back down to the Fifth Circuit to figure out the specifics of what notice is due. The court was also very clear. This decision, it's only about the right to notice, the due process part. It's not about whether the removals themselves under the Alien Enemies Act are legal or not. That's a separate question. They acknowledged the government's national security points, but stressed, these things have to be done consistent with the Constitution.
Now, while the court agreed on stopping the removals for now, there wasn't total agreement on the path forward, or even if the court should have jumped in like this. Justice Kavanaugh, for instance. He agreed with the temporary injunction, but he seemed to want things to move much faster towards a final answer.
That's right. Justice Kavanaugh wrote a concurrence. He agreed with the outcome of the injunction because it ensures the courts can decide if the removals are lawful before they happen. That's key. But he explicitly laid out the 2 big legal questions still hanging out there. First, does the Alien Enemies Act even apply to these specific detainees? And second, if it does, what kind of notice do they constitutionally need? He also pointed out, look, different federal courts have already reached conflicting answers on these questions, so there's a need for clarity from the top.
And he really emphasized the urgency felt by everyone involved, didn't he? The executive branch stressing national security, the need to remove TDA members quickly, very urgent from their side. But the detainees themselves were also asking the Supreme Court to move fast to resolve their situation.
Exactly. So given that urgency on both sides, Justice Kavanaugh felt the court should have basically skipped a step. He wanted to grant certiorari before judgment. Fancy term. But it just means taking the case directly from the district court, bypassing the full Fifth Circuit review. His thinking was, let's just grab it now and resolve these big legal questions ourselves promptly instead of sending it back down. He saw it as the quickest way to get a prompt and final resolution on something this important.
But, as often happens at the Supreme Court, there was a strong counterargument, a dissent. Justice Alito, joined by Justice Thomas, disagreed pretty fundamentally. They argued the Supreme Court shouldn't have even taken the case at this stage.
Right. Justice Alito's dissent kicks off with a foundational point. Jurisdiction is power to declare the law. His core argument. The Supreme Court didn't have jurisdiction here. Why? Because he believed the district court had not constructively denied the injunction. He felt the majority basically misread what happened down there.
He painted a different picture of the district court's actions, didn't he? Less inaction, more irreasonable in it. Yeah, he characterized the detainees' lawyers as delivering an ultimatum, demanding a ruling in, 42 or 133 minutes, where they'd appeal. He called this a stark departure from what is usually regarded as acceptable practice, basically suggesting they were trying to bully the court.
That's the gist of it. Justice Alito stressed that the district court was actually working diligently on important and complicated issues, and it was simply waiting for the government's response, which was due within a perfectly normal 24-hour deadline set by the court itself. He also really hammered on the idea that the factual support given to the district court at that initial moment was weak. He argued there wasn't solid proof then that the specific named plaintiffs were about to be removed immediately. And he criticized the majority for relying on information that only surfaced later to justify the urgency. He felt that wasn't fair to the district court's original position.
Justice Alito also brought up a really significant legal question about class relief. The idea that this lawsuit could cover a whole group, a class, of detainees. He questioned if that's even allowed in habeas corpus cases.
Yeah, that's a big one. He explained that class actions, which are governed by Rule 23 of the federal rules, are typically for civil lawsuits. Money damages, injunctions in civil context, things like that. But habeas corpus, that's historically been very individual. It's about your specific detention. Is your jailing lawful? He argued there's very little historical basis for applying class action rules to habeas proceedings. Plus, he argued the specific named plaintiffs here, ARP and WMM, weren't really typical representatives for a class needing immediate notice relief. Why? Because they already had their own separate habeas petitions going, and the government had already promised them they wouldn't be removed while those were pending. So their situation, he argued, was different from others who might not have had those protections yet.
And he pointed out something else that happened later, right? About the class certification itself.
Exactly. He noted that the district court, after doing a more thorough review later on, actually denied class certification. The district court judge concluded that due process is by its very nature individualized. What's fair notice for one person might depend on their circumstances. The dissent felt the Supreme Court majority basically jumped the gun and ignored this crucial development that happened after the initial emergency scramble.
So what was Justice Alito's bottom line on the Supreme Court stepping in so quickly?
He really slammed the decision to grant that certiorari before judgment, taking the case before the appeals court finished. He called it an unusual step and argued it goes against the Supreme Court's main job, which is usually to be a court of review, not first view. Meaning, they typically review decisions already made by lower courts. They don't usually jump into the middle of things. He felt the court was blazing a new trail here, acting too much like a trial court, a court of original jurisdiction, by intervening so early. His dissent really captures that ongoing debate within the court itself. Are we primarily careful reviewers, or sometimes do we need to be first responders in national crises? Even if it means bending the usual procedures, it's a deep disagreement about judicial role.
Wow. Okay, so this whole deep dive, this whirlwind of legal action, the sharp disagreements, it really reminds us, doesn't it, that our legal system is in this constant state of balancing really powerful interests, national security on one side, executive power, and then fundamental individual rights on the other. It's a constant negotiation.
Absolutely. And even if you listening aren't a lawyer or hopefully never find yourself in a situation like this case shines a bright light on the role of due process. It really is fundamental. It's about fair warning. It's about access to legal help. It's about the right to challenge what the government is doing. These are principles that, they underpin a just society for everyone, regardless of who they are or where they're from. That question, what notice is due, it directly impacts how real people facing potentially life-changing things like deportation can even interact with the system to protect themselves. It shows that even when the accusations are incredibly serious, like being part of a terrorist group, the process itself has to meet constitutional standards.
Yeah, what a journey. Through the Supreme Court, through the appeals courts, this incredibly fast-paced world of emergency legal action. I mean, from an urgent situation to a Supreme Court order in less than 48 hours. It really shows how our judicial system tries to handle these incredibly complex issues under immense pressure. Decisions that affect individuals so profoundly and also shape national policy.
It definitely leaves us with something to think about, doesn't it? In this age where information travels instantly, where threats can feel so immediate, how fast is too fast for justice? And how do we make sure that fundamental rights, like due process, are truly protected, even when national security concerns are absolutely front and center and that clock is just undeniably ticking?
Good questions to keep in mind as you reflect on this deep dive. Thank you so much for joining us for this crucial look into the workings of the Supreme Court.